You guys are crazy, man. I said, you guys are crazy.
He's kind of read instruction, right?
Mm-hmm. Yep. This is gonna be interesting.
Please remain seated in front of 16 will now come back to order.
On the record.
All right, let's go ahead and set forth our appearances on the record. We'll start first with the plaintiff, then we'll move to the defense.
John Wilkamp for plaintiff.
Good afternoon, Your Honor. Teddy Parker for plaintiff.
Robert Eglett for plaintiff, Your Honor.
Dr. Federico for plaintiff. Brianna Switzer for plaintiff.
Brad Johnson, Eric Freeman, Michael Esposito, and Tyler Watson, defendants.
All right, counsel, we ready to bring the jury in?
Yes, sir.
Yes, Your Honor.
Okay.
My knee before. He said, you guys are playing.
You think you were better
Thank you.
under pressure.
I appreciate it.
We both think he looks better under pressure.
Well, he has done this 4 times before.
Yeah.
I don't know what him and Shane were doing.
Dude.
That's what I was wondering.
No, you guys, you know, I mean, make this look easy. It ain't. Oh, God.
I will.
This is funny.
We should think of some kind of handicap to give you.
Yeah, thank you. I appreciate it.
Don't use a word limit or something.
Yeah, right, yeah. It's like playing golf. You can't.
All right,
You know, you're playing with a 7-iron. Putting, chipping, driving with a 7-iron.
One time I played 9 holes just using a 7-iron. I shot a 39.
10 cut.
No, I played 9 holes using just a 7-iron. I shot a 39.
On the first hole.
No, the whole. I used it as a putter the whole. Come on, it was the first hole.
I was wondering.
All right, do the parties stipulate to the presence of the jury?
Yes, Your Honor.
We do, Your Honor.
All right, ladies and gentlemen of the jury, I hope you enjoyed your lunch. And it's my understanding, counsel, we're going to go to the final phase, the punitive damage phase. Is that correct?
Yes, Your Honor.
Mr. Johnson?
Yes, sir.
All right. Okay. And ladies and gentlemen, just like the compensatory damage phase, we do have a jury instruction I have to read to you regarding the punitive damage phase. You understand that? And so anyway, this is jury instruction number 1 for the punitive damage phase. Ladies and gentlemen, there are no fixed standards for determining the amount of a punitive damage award. The amount is left to your sound discretion to be exercised without passion or prejudice and in accordance with the following governing principles. The amount of punitive damage award is not to compensate the plaintiff for harm suffered, but what is reasonably necessary to punish and deter the defendant and others from engaging in conduct such as that warranting punitive damages in this case. In arriving at an award of punitive damages, you are to consider the following. 1, the reprehensibility of the conduct of the subject defendant, and 2, the amount of punitive damages that will serve the purposes of punishment and deterrence. All right. I think the next is oh, I'm sorry. Thank you. Jury instruction number 2. Punitive damages may not be awarded in this action for the injury or death of a pet. All right. Okay, and the parties stipulate that Phase 2 punitive damages instructions 1 and 2 have been read to the jury.
Yes, Your Honor.
Yes, Your Honor, subject to the objections stated.
Of course.
Thank you, sir.
Okay, are we ready to start, Mr. Eglett?
Yes, thank you, Your Honor. Well, good afternoon, ladies and gentlemen. We're almost done.
sure you're excited about that. I know I am. I'm, 65 years old. I want to get some sleep this weekend. Is what I need. I do want to start out, again, thanking all of you for your service. We know how much time you put into this, and we saw how many notes you took and how much attention you paid to everything. And on behalf of my client, Lisa King, I know she really appreciates your service and your contemplation, your sound contemplation, and your verdict in the compensatory phase. Now, this is the punitive phase. I also want to thank my young associate, Maggie Federico, 28 years old. This is her first trial. And she did 3 witnesses in this trial, and I think she did just a wonderful job. I also want to thank the court and his staff, who are always so professional when we're trying cases in front of them. I think this is like my 5th or 6th trial in front of you, Your Honor, something like that. And it's always enjoyable. I want to thank defense counsel for their efforts in this case as well. It's going to probably come as a surprise to you, but Mr. Johnson and I are actually very close friends. In fact, our wives are friends, and we have plans to go out to dinner after this trial's over with. So now, lawyers, we fight, but if we didn't leave this in the courtroom, we wouldn't have any friends, because no one will be friends with us except other lawyers. So we're friends, and of course that doesn't excuse my outburst and calling him the L word, and that was inappropriate. And I think I called him that. I said he did do that. But at any rate, I don't want you to think that we hate each other. We're all friends, and we know we have to leave it in the courtroom or we could go crazy. So I hope you didn't read anything that we were like, bitter enemies, because we're not. We're friends. So at any rate, I'm going to give you a summation here, and then Mr. Parker is going to give you a summation, and Mr. Johnson will go, and then Mr. Parker will probably come up and give you a rebuttal. So, punitive damages. So, we don't always know why things happen in life. But somehow, against all the odds, you were chosen, the 10 of you here, to be here today for this community, our community, and for the future, quite frankly, of all communities. It seems random, I know, that 2.4 million people in Clark County, in this community, that you were chosen to come to jury selection for this case. And most of you here probably not wanting to be on a jury, as most people initially don't. You probably have a different attitude now about going through this for 4 weeks. I'm sure you guys have learned a lot. But probably when you first got here wanted to go home. You probably could have gotten off jury selection, off the jury, if you wanted to. There's ways, and you're all intelligent people. But for some reason, something made you stay. And who knows why it worked out that way. But, the one who's in charge of right and wrong in this world made the right choice, in our view, with the 10 of you. Because we've watched you throughout this trial, as you closely paid attention to all the evidence and all the witnesses and how you've taken notes. Some of you never stopped writing, it seemed like. We watched you. I think my fingers and hand would fall off if I wrote as much as you guys did. But you're concerned every day about 13 strangers. It's not the kind of thing that most people do all day. And so something put you here for a reason, and we believe you are here to make not only our community, but all communities safer by your verdict in this exemplary or punitive damages phase of this trial. You see, a jury is the most powerful group a person could belong to. It really is. And that's why nearly every other country in the world, save a small handful, don't have them. They don't have jury trials. It's why corporate America has been fighting to do away with the jury trial in America for more than 7 decades. You see, juries are truly the last checks and balances we have against corporate corruption. And we know, quite frankly, and I know it's not lost on you guys, how ineffective Congress is at standing up to them. And there's a simple reason for that. It's because corporate America has an unlimited amount of money to fund their campaigns. And as much as any of our presidents, past and present, may try, without a Congress with a backbone, or whose only real goal is to get reelected and not actually work for the American people, they can't get the votes from Congress to stop corporate America from steamrolling American citizens. And I'm not saying that all corporations are bad or corrupt. They're not. We have a lot of really, really fine, good corporations in this country. And believe me, I'm a capitalist through and through. If it wasn't for capitalism, I wouldn't have been able to rise from abject poverty to being able to do what I do. But just like any other profession, lawyers, doctors, accountants, you name it, there are a lot of bad and corrupt corporations out there that don't tell the truth and don't follow the rules, and that have to be held accountable for their actions. So you see, juries in jury trials like this are the only way we have to prevent bad corporations in our country from having total control and stripping ordinary people of the ability to effectuate positive change in our country. Because that's what juries can do in these phases of the trial. And it's the only way we have left for an ordinary American citizen to have their voice heard when it comes to these issues. And that's why corporations have been fighting so hard for so long to destroy our only remaining place of hope, where regular Americans can hold corporations responsible if their greed, indifference to safety, and higher profits at all costs attitudes overrun the responsibility they must have to the public and their customers. So you need to tell this company and all other companies similarly situated that in this community, in our community, the safety of people is more important than the safety of this corporation's profits. The problem is that they don't put value on human well-being and safety. You saw it for yourselves. They did not value human safety and well-being when they manufactured hydrazine into their bottled water and ignored all the safety warnings about their water. Nearly 100 people in our community had liver failure or significant liver damage from drinking real water. Of these were 5 babies, 3 children, 3 of the adults contracted autoimmune hepatitis, 1 contracted myasthenia gravis, and 2 died. So what do you think will happen if you give them a pass and you let them off with a bargain basement verdict, a slap on the wrist? And what will that tell our community? Human well-being and safety is on sale in Las Vegas. The bottled water industry will just continue business as usual. They won't bat an eye and will continue to not really tell you what's in their water, in their labels. Because they don't have to now. And your verdict will bring about no change if your punitive damage verdict isn't high enough to force them to effectuate change. No one in the bottled water industry will take notice, and none of them will be deterred from engaging in similar conduct in the future. But you can be the ones that prevent something like this from ever happening in the future, or something like this will happen again. It's your decision. It's your choice. You have the power to decide that. And only you have the power to decide that. So which that will be? It's your decision, not mine, not the judges, it's all yours. Every CEO and president in the bottled water industry is watching to see what you do through those cameras. So if you want to ensure something like this never happens again in America, your verdict must be loud, because they have their hands over their ears. You must make them hear you with your verdict. They must hear you all across Nevada, from Las Vegas to Reno. They must hear you across the country, from Seattle to Miami, and from New York to LA. If you want them to hear you, it must be loud enough so they hear you. From Las Vegas to Wall Street, and every city where bottled water company corporations are headquartered or manufacture their product. The purpose of punitive damages is 1, to punish the defendant, 2, to deter defendant's future misconduct, and 3, to deter other bottled water companies from engaging in misconduct. Misconduct is not just the hydrazine in the real water. That is the result of all the misconduct. So with your verdict, you need to deter defendants and other bottled water companies from placing profits over safety of the public and their customers. Because juries spoke loud enough with their punitive damages verdicts, cars are safer. You think airbags are and seatbelts are in cars because of legislation? It started with jury verdicts. Tires are safer. That came about from jury verdicts. Toys are safer. That came about from punitive damages and jury verdicts. Baby cribs are safer. That came about from punitive damages and verdicts. Factory machines are safer. Paint is safer. Installation is safer. Hotel guests are safer. Commercial buildings are safer. Home appliances are safer. Seat belts are safer. Dangerous drugs are off the market. Large dangerous vials of anesthetic are not allowed in inpatient facilities. That was a case Mr. Kemp and I did together. Injection practices are safer. Another case Mr. Kemp
Your
and
Honor, I'm
I
gonna
did together.
object to justice of cause.
HMO
Wait,
credentialing is safer.
Overrule, go ahead.
Thank you.
Another case that Mr. Kemp and I did together. Off-road clothing is now fire retardant. Off-road motorcycle clothing is now fire retardant because of another case I did earlier. And you will make bottled water companies safer. So this is the punitive damages instruction the judge read to you. You'll have it when you are back in the jury deliberation room. I don't know how to read it again, because you guys can read it back there, but I am going to point out a couple of areas to you. Regarding what you should consider in your verdict, Mr. Parker will be taking this part. In arriving at award of punitive damage, you are considered following: one, the reprehensibility of the conduct of the subject defendant. After I sit down, Mr. Parker will get up and he'll go through all that part of the jury instruction with you. What I'm going to talk to you about is the amount of punitive damages that will serve the purpose of punishment and deterrence here. So, as jury instruction number 4 tells you, one of the parties in this case is a corporation. A corporation is entitled to the same fair and unprejudiced treatment as an individual would be under like circumstances. And you should decide the case with the same impartiality you would use in deciding a case between individuals. To treat corporations and people the same. So let's look at that. The average American salary in 2025 is $66,622 a year. $66,622 times 3% is $1,999. To pay a fine or punitive damages amount in a case where somebody is driving and they are drunk or high on drugs when they're driving, and they hit and injure someone. Well, and they have a punitive damages fine against them for doing it. Well, they can budget money to do without certain things to pay that punitive damages award, or they can get a part-time job and make additional money to pay that, or they can take out a home equity loan if they own a home to pay for that. There's ways they can do that, and there's similar ways that companies can do that. But if we just took that 3% of their income, let's assume that the person, the drunk driver making the average American salary, gets in an accident when they're drunk and they hurt somebody, and the jury awards punitive damages against them for driving drunk, which is what happens in Nevada and most states. If you divided that $1,999 by 52 weeks, that would be $38 a week for that individual. Nevada's current minimum wage is $12 per hour. If they, at $38 per week at $12 per hour, they would have to get a part-time job making minimum wage, working 3.2 hours per week for a year to pay that fine. Or 1 extra hour per day, 3 days a week. Or 1.6 extra hours per day, 2 days per week. Not unreasonable, seems pretty fair. Someone's drunk, driving, they injure somebody, maybe severely. And the jury says, well, you're gonna have to pay 3% of your income this year, the revenue or the income you generate in this punitive damages claim. Corporations and people should be treated the same. The U.S. bottled water industry will make $100 billion in revenue in 2025, and it's rapidly growing, as Mr. Rich told you in his testimony. $100 billion times 3%, the same, which is a reasonable amount for punitive damages for the ordinary American making the average salary in this country, is $3 billion. Does that seem unfair and unreasonable? Wouldn't for an average American, why would it for a corporation who is supposed to be treated the same? A 3% exemplary damage verdict will send an appropriate message by you that this should never be allowed to happen again in our country, and will force them to change business as usual. 100 acute liver failures and acute liver injuries, including 5 babies and 3 children. 3 real water victims had autoimmune hepatitis. Lisa King has autoimmune hepatitis and myasthenia gravis. And 2 real water victims died. And this is their CEO and president's reaction.
No, I did not think that there was any problem with real water in October or November of 2020. I was completely blindsided when it happened in March.
No remorse, no apology, only concern for himself, and he didn't even show up at this trial.
Judge, Your Honor, he did show up. There he is.
He didn't show up in person in this trial, like all of the plaintiffs did, almost nearly every day. That's how much concern he showed for what his company did to our community. Ladies and gentlemen, as jurors service, your service is a public trust. Obviously, a juror's verdict is public property. We must now live in your public trust, and your verdict must now serve us as public property for all times. In rendering your verdict, you will write history, which is recorded here in this courthouse for all times, for all people, for all generations, to come and see what you have written under these circumstances here. Not for this moment, but for all time. This will be your verdict. This isn't my verdict, Mr. Kemp's verdict, Mr. Parker's verdict, the defense lawyer's verdict. This is your verdict, ladies and gentlemen. And it is only you who can write this particular history. You have heard me suggest that you place in the verdict a large sum of money, but when compared to what an ordinary American citizen would have to pay in punitive damages, they have to be treated the same. It should be the same. But in doing so, you must realize your verdict forever stands, now and forever. Your great-grandchildren's grandchildren will be able to read.
Objection, Your Honor, golden rule.
This isn't the golden rule.
Yeah, it's not. Overrule.
Your Honor.
The history you will write today. And in our judgment, you are going to be one of the proud members of whom it will be said that you gave so much because this situation demanded so much. Therefore, let your verdict be a proud moment in history for you and all others, a proud moment where it will be written that a jury in Nevada made the bottled water industry safer for all Americans, that a jury in America that changed the bottled water industry for betterment, for the betterment of all Americans. Thank you.
Thank you, sir. Mr. Parker.
No, I don't. They don't trust me to use the screen. I rely on Shane, and if I'm not here, I rely on the children. May I proceed, Your Honor?
Yes, you may, sir.
Thank you. Good afternoon, everyone. You guys starting to look tired. You good? Everybody good? I'm gonna move this up the way a little bit. Let's start with the first slide, Shane. Let me first start, and see that, Ms. Garcia, you can't start laughing, okay? The whole group is laughing. So, let me first tell you why I'm starting with this slide. When I thought about this last night, late last night and early this morning, I was trying to figure out who could I compare Real Water to in terms of their approach at customer concern. And I said, well, why not take one of the richest companies in the world? So Sam Walton founded Walmart in Rogers, Arkansas, very small city. I'm from a small city in South Carolina, so I know, very small city. Walmart now operates 10,500 stores in 19 countries, employs 2.1 million associates around the world, 1.6 million in the United States alone. Walmart remains the #1 richest company for the 10th consecutive year. In 2022, Walmart reported $573 billion in revenue. And I said, well, what made Walmart what it is? And you know why? It's because Sam Walton put the customer on a pedestal. Not the president, not the vice president, the customer. And one thing that we know, and I thought about this last night, I was surprised because Mr. Eglin and I did not work together on these rebuttal arguments.
Closing argument.
Closing arguments, we'll do rebuttal later. You guys are, he's over here kind of. All right, the point is, virtually his last slide, was the testimony of Mr. Brent Jones, the president. And he said he was blindsided. If you are paying attention to your customers, how can you be blindsided? How? When you have as many terminations for medical reasons, when you've received so many, dozens of complaints based on medical conditions. How could you be blindsided? I can tell you who would not be blindsided. Sam Walton. Next slide. Mr. Walton said there's only one boss, the customer, and he can fire everybody in the company, from the chairman on down, just by spending his money somewhere else. And then he said, high expectations are the key to everything. What are your expectations? What should the expectations be of someone buying bottled water? Shouldn't they expect that the water is safe, sanitary, not poisonous? Those should be no-brainers. Your verdict, at the end of the day, will reinforce those expectations. because real water has torn them down. For over 13 years, real water poisoned its customers. That's what's happened. And there's been no testimony from this stand saying otherwise. Real water didn't bring in a toxicologist to say hydrazine really wasn't in the water. The FDA had it wrong. Eurofins had it wrong. We know that that's what happened. And instead of correcting that problem for over 13 years, they fought these plaintiffs for the last 3 years. Ms. King, Ms. Bordenave, they've lived for this for over 7 years of their lives. Until February 10th of this year, they refused to admit their product was dangerous, unreasonably safe, and it contained the toxin. And that's why we're here. And I remember distinctly, I was thinking about this while I was on the treadmill running last night. I remember distinctly each of you agreeing that while there may be frivolous cases, there are frivolous defenses. And there should not be frivolous defenses used to deny people how they've been harmed and to delay their opportunities to be in front of a jury like yourselves. But that's what they've done for 4 years. Next slide. We should be able to expect that new and different water bottling processes will be tested before the sale of the public. And I put these up because this is what your punitive damage amount should impart on real water and the bottling water industry. These are the expectations that should come from your verdict. We expect that the finished product will be tested, non-targeted GCMS testing, before they market it, before they sell it, and certainly before people start consuming it. Is that too much to expect, and is that too much to ask? We expect the customer complaint to be investigated thoroughly, and if answers are not discovered, production will be stopped. Next slide. We expect that production will be halted until the medical mysteries related to their product are resolved and people return to good health. We also expect the recalls will be enacted if and when products are discovered to be dangerous to the public. In this case, we know we have hydrazine in the water, and we know hydrazine is a known liver toxin. There's no dispute. We also discovered in this case that not only was there a poison hydrazine in the water, but there were coliforms in the water, human feces in the water. That's what these people were consuming. So when Mr. Eglett got up and discussed generally the process, and when Mr. Kemp discussed with Dr. Hutt what testing they did do, even their own testing for bacteriological issues resulted in passing tests that had coliforms in it. That's their process. Their process did not eliminate hydrazine, and it didn't eliminate human feces in the water. 13 years of selling that product, and the process didn't change. Next slide. Companies should be expected to place health and safety ahead of production and profits. This is here because if you remember what Patricia Converse said. Patricia Converse said, Real Water, and in particular, its vice president, were not concerned on Monday mornings about claims or investigations. What were they concerned about? Getting those trucks with those bottles of water out the door. How many trucks delivered water? That's it. That's what they were concerned about. They weren't concerned about avoiding exposing their customers to the same consequences we've been talking about for the last 4 weeks. 4 weeks. And you guys have been patient, more than patient. You've dealt with extended periods outside, and I can tell you, for everyone here, we've been sitting here working while you've been out there. The time was not wasted, and we apologize, all of us. I do that on behalf of everyone on this side of the room, as well as everyone on the other side of the room. But these are the consequences. One death, that was reported in the MMWR reports, a lady at the age of 60. 2 liver transplants, both young males. Their lives cut in half. Ms. Boardnave, Ms. King, incurable, AIH, and Ms. King also is burdened now the rest of her life with myasthenia gravis. Sever Morales, child with a biopsy, 22 months old, cirrhosis at 22 months old. 3 of the plaintiffs in this case had biopsies, 4 associated with the Loma Linda, 20 to 25 reported customer complaints. Now that came through the FDA report. How in the world can Brent Jones say he was blindsided? And you ladies and gentlemen had last night to think about this, and this morning. Mr. Brent Jones said one thing, Mr. Blaine Jones said something else. So either Mr. Brent Jones was not paying attention, or he was not being honest. Same with Blaine Jones. How can they be blindsided knowing that they had 20 to 25 reported customer complaints based on health issues, 37 customer delivery terminations related to medical issues? And that's confounding to me. If someone's canceling their subscription to your water product or any product, I know what Sam Walton would have done. It wouldn't be blindsided. He wouldn't turn using Mr. Eglet's slide from yesterday. He wouldn't do this. We know that. 18 customer complaints. We showed you and played several of those. I won't replay them for you. You remember. Mr. Randolph, the vice president of distribution, his nephew being hospitalized, his best friend's, his brother-in-law's best friend being hospitalized, Blaine Jones being hospitalized. The only commonality is the real water. Dr. Hudson has reviewed medical records from 46 patients that have, or plaintiffs, that have suffered acute liver injuries and acute liver failure from consuming real water. Dr. Alcina, real waters expert, 46. All because of real water, complete indifference to the health of the customers and the public. Next slide, Shane. Now this is jury instruction number 1 for this phase. One thing, and Mr. Eglet went over this, but one thing I wanted to point out is that punitive damage award is not to compensate the plaintiffs for the harm suffered, but what is reasonably necessary to punish and deter the defendant and others. This is not about the plaintiffs in terms of your amount. Your amount is to make a change, make a difference for Real Water who didn't show up here, but for every Real Water company like that. Because you're sending a message to all of them. This will not be tolerated. Next slide, Shane. Now, Mr. Rich testified earlier today, this morning, that the US market alone is 100 billion plus. 100 billion plus. That reflects 1 year of annual revenue. 1 year is 100 billion plus. Real Water has been generating, strike that. Real Water has been a part of the bottled water industry now for many years. In terms of this case, we've been dealing with 13 years, from 11 years actually, from 2008 or 9 to 2021. That's what we've been dealing with. For all those years, this market has been generating large amounts of money. Our request, based upon Mr. Eglet's suggestion to you, is 3% of 1 year. Not 3% of 10 years or 11 years or 13 years, just 3% of 1 year. These plaintiffs and others have suffered for several years, not one. Ms. King, seated over there, 7 years. And she'll be dealing with this for the rest of her life. So when we ask for 3% of 1 year, we want to just put it in context. Next slide. He also indicated that it's estimated this $1 billion market, $100 billion market for 1 year will be $135 billion. I say that in terms of where it's going. It's a 6% increase is what he's seeing every year. I say that because your decision won't just affect a $100 billion market. As the market grows, it will affect everyone else coming into the market. Everyone coming up with unique and bizarre ways, using Mr. Kemp's words, of making water. So every time someone comes into this market, your decision will say, you have to test. If it's something new, test. Test the process, test before you sell it. If something comes up, you test again. You don't ignore your customers. Go right ahead, Shane. This is what Mr. Rich said as a minimum. He said a minimum to make a positive impact. Ladies and gentlemen, we're suggesting 3%. He said a minimum to make a positive effect. And that's what we want you to do. That's what's required, a positive effect. Next slide, Sean. And this is the easy numbers. I don't need to spend time on that. Go right ahead, Shane. I bring this up just to remind you. These are some basics, but these are mistakes. These are conscious mistakes that they made year after year after year that the FDA, the Southern Nevada Health District, and the CDC found. And you can read them. They're in the report prepared by the CDC and the FDA and the Southern Nevada Health District. And we found out, and I showed it yesterday to you in closing, just how deceptive real water employees were when the investigation began by the CDC and the FDA. Now, these were findings by the FDA and CDC, which we've gone over. Next slide, Shane. And despite those types of findings, and despite Mr. Randolph, the VP of distribution, going to Mr. Blaine Jones and telling him, stop, you gotta do recall, it's about the water. This was Blaine's response. He's still trying to push the concentrate. That was his response. Next slide. So I want you to consider just the opposite of what Mr. Eglett said. I want you to consider what would happen if you don't send a message. This would be the message you will be sending if you don't award something meaningful enough to make a positive difference. You'll be telling the bottled water industry it's okay to create a new product or a new manufacturing process without testing the safety of the process or the product. And Dr. Hutt spoke to that issue. It's okay not to conduct non-targeted screening before marketing and sales. It's okay to ignore customer complaints of sickness caused by your product. It's okay not to investigate customer complaints, which we saw repeatedly in this case. In fact, there was a complaint when one of the customers said, I've sent you the information, I've inquired, I'm doing this for the benefit of the company, no response. That's what Real Water did. It's okay not to test the safety of your product after customers have reported health problems. Next slide. It's okay not to have a qualified QA or QC employee. It's okay not to stop production when employees and customers are getting sick from consuming products. And it's okay to mislead and deceive the FDA, CDC, and the Southern Nevada Health District. Next slide. It's okay to refuse to cooperate with the FDA, CDC, and the Southern Nevada Health District. So yesterday when we went through and I did my closing, I showed you evidence of Blaine Jones scheduling appointments with the CDC and refusing to show. Showed you evidence of his refusal to answer the investigator's questions. Showed you evidence of his failure to even reveal the location of the concentrate room. Showed you evidence that he would not inform the FDA how they were ionizing the product. Wouldn't even show it to him. And refused to provide documents. If you're concerned about public health and public safety, how do you do these things? Next slide. You have to send a message that it's not okay to issue a recall after receiving numerous customer complaints and medical issues, and after the Vice President of Distribution concludes that real water was the common denominator in the hospitalization of Mr. Blaine Jones, his nephew, a friend of his brother-in-law, and countless other customer complaints received by Real Water. Shane. The Real Water product was determined by the FDA and the CDC to be adulterated, unsanitary, filthy. And they didn't know at that point that it included human feces when they made that decision. The CDC indicated that they were not in conformance with good manufacturing practices. They didn't maintain records of testing. You have to send a message that prevents something like this. You have to send a message that tells the bottle industry that they are required to cooperate with the authorities that are charged with the protection of health and safety of the public. Next slide. I'm gonna leave it here because I get one more chance. But I want you to consider those things, the evidence, what Real Water did in an attempt to avoid responsibility. And as you consider Mr. Johnson, I'm assuming Mr. Johnson is going to give the next argument. I want you to keep that in the back of your mind until I get a chance to speak to you again. Thank you, ladies and gentlemen.
Thank you.
Thank you, Your Honor.
All right, Mr. Johnson, sir.
Thank you, sir. Thank you. This case isn't about the attorneys. It's about verdict, what the facts were, what the evidence was. And you know all the evidence, you know all the facts. Carefully consider those facts, and you rendered a verdict, and we respect your verdict. You're not happy about what has happened in this case because you've elected to check that punitive damages are appropriate, and I respect that. And that's what I wanted to address, and that's what I will address. I didn't say this is going to be an hour. We gotta address this. The judge stated what the standards were for punitive damages, yet the two punitive damage openings we have seem to have ignored that. And so I'm going to address that. This is about money, okay? We all know that. It is your sophisticated right. That's what this is about. The judge says you need to make that determination to punish and deter without passion. That's the jury instruction. Here we go again. It's the same stuff. We're talking about babies, dogs, other cases, right? That is to elicit passion and emotion. And if we've done anything in this case, we haven't appealed to that because that's not what you're here for. It hasn't worked in the compensatory stage. I'm assuming it's not going to work in the punitive damage stage because that's the law. You cannot base your positions on passion or prejudice, but that's what they preach over and over and over again. Sure, that's not lost on you. This is about money. They state this isn't about compensating the plaintiffs, but then they talk about the plaintiffs again and what they went through. Okay? This is supposed to deter a bottled water industry of which you heard zero testimony on, right? You didn't hear anything about the bottled water industry. You didn't hear any testimony about how the bottled water industry's run amok. You didn't hear anything about, the whole bottled water industry's got some poop in the water. The whole bottled water industry isn't listening to customer complaints. The whole bottle, you know what? America needs you to send a message to the bottled water community so they don't operate like Real Water. Do you think that's what this case is about? Is that what you think's happening here? That's what's happening here. What are we deterring here? That is what they're claiming, that we need to deter. We're bottled water company is destroying.
Yes, you can. Ladies and gentlemen, I need a quick recess, and we'll take a break. You might need one too, because we've been going for about 2 hours now, give or take. Anyway, remember, you're admonished not to converse amongst yourselves or with anyone else on any subject matter connected with this trial, or to read, watch, and listen to any report of or commentary on the trial by any persons connected with this case, or by any medium of information, including without limitations, newspaper, television, radio, social media. Remember that. And last but not least, do not form or express any opinion on any subject connected with the trial until the cause is finally submitted to you. We'll take 15.
All right, for the jury.
All right, what we'll do, we'll step down for a few moments, run to the men's room or ladies' room, and come right back, and we'll discuss the issue. All right, we'll be in recess.
Sharon, Mr. Kemp is still in the restroom.
Okay, we'll wait for him.
On the record, no.
All right, gentlemen, we're back on the record. And ladies, of course.
May I approach, Your Honor?
Yes, you may. Yes, you may proceed, sir.
Hey, Your Honor, what happened here is what we're arguing is a Yochi violation. He put the dollar sign on the screen, not a little dollar sign, a two-foot wide one. And he said to the jury 3 times, "This is about the money." And then he looked over at the plaintiff. Okay, so what he was clearly trying to do, and he conceded to this at the stand, is he was trying to argue to this jury, don't give millions of dollars because the plaintiffs will get the money, and that's just too much money. And that's an inappropriate argument, Your Honor. He's not the first attorney who's tried this. I will refresh your recollection that in the HMO case, Mr. Roberts tried something similar, and we stopped him in his tracks. But that is not an appropriate argument because the purpose of punitive damages is not to compensate plaintiffs. And the award is what's necessary to punish and deter the defendant and others. Has nothing to do with where the money's going. And that's why some states have statutes that specifically address this and award money to different places, like Georgia, for example. But what he's done, and again, this is a temptation that most defense attorneys fall into at this point in the case. But it's wrong. And so what we've written is a curative instruction, and we've taken the language directly from the jury instruction. A punitive damages award is not to compensate the plaintiffs. Mr. Johnson has argued that this quote, is about the money, unquote, and implied that the amount to deter the defendant and others should be reduced for inappropriate reasons. And I use inappropriate reasons because we don't want to say the reason he's trying to express to this jury that, you know, don't give these people the money. It's a lot of money for these people. That's the argument he's trying to make. I don't want to repeat that or clarify that or specify that or point that out here, so I just said for inappropriate reasons. And then your sole focus should be on determined amount, quote, reasonably necessary to punish and deter the defendant and others, unquote. That's directly from the instruction. But John, I think we need this curative instruction right now, and I'd ask that he not continue on this vein, leave this dollar sign out, quit staring at the plaintiffs every time he says this is about the money, because it's just not an appropriate argument, John.
Your Honor, I will tell you honestly, I wanted something much stronger than this, and well, Mr. Kemp, usually being the tempered one, offered one that was much more tempered down. But if you don't give this instruction, and you don't in fact admonish Mr. Johnson here and now, before he starts up again, he has to stop this inappropriate argument, it's just going to continue. We're going to be having objection and sidebar after sidebar after sidebar. Eddie, do you want to add anything?
I agree with Mr. Eglin and Mr. Kemp on this, Your Honor.
That was stunning. No, Mr. Kemp can regale us how he goes read the Gettysburg Address, really don't care about other cases he's been in. Bottom line is that they had gotten up in front of the jury, as they are entitled to do, and put a $3 billion number up on the board. Fairly certain there's a dollar sign in front of it. It's all about the money. That's what they're asking for, $3 billion. The jury instruction states.
But here's my question, and ultimately, and I thought about it, and I did go back and take a quick look at Leoshi, and I forgot it was such a long case. You know, it's pretty long. And one of the concerns I have, and it dealt specifically with arguments of defense counsel potentially arising to the level of impermissible jury nullification. And that's really and truly what the issue is. And the reason why I say that is this: it's easy to say, well, it's about the money, but really, when it comes to punitive damages, it's about punishment and deterring. And our punitive damage instruction specifically says, quote, the amount of punitive damage award is not to compensate the plaintiff. And that's the instruction I've given in this case. And so I get that, I understand, but anytime we talk about it's all about the money, it's not really about the money, it's to deter and to punish. And I'm concerned about the issue regarding potential impermissible jury nullification, and that's straight out of Leoshi. So what do I do?
Well, first of all, I haven't done anything inappropriate. This is about the money. They're asking for $3 billion. It's a punitive damage stage. Did they produce any case law that states the jury's supposed to think that this money goes off into space or to, what is it, a charity of some sort? There's a jury instruction of how much money to award. That's what the case is about. I've stated, I apparently am the only one who's following the law in this case because I said it's supposed to deter and punish. What we got instead was Mr. Egley got up there, brought up Miss King directly. It's not supposed to be about her, but I guess it is again. Mr. Parker, not to be topped, brought up his client again. It's not supposed to be about compensating them, yet they're talking about how they've suffered, etc. Your Honor, the jury
but here's my question in that regard.
Yes, sir.
When it comes to punishment and deterrence, wouldn't you look to the potential impact of the conduct that rose to a level of conscious disregard?
Right.
I mean, that's ultimately what it comes down to, because you remember this, when it comes to the award of punitive damages, they were given instructions, and it's my recollection we followed probably to the TNRS 42.005 as far as the specific definitions. And so my point is this, when it comes to punishment and deterrence, are you saying that, look, you don't look at the results of the conduct that rose to a level based upon a conscious disregard supported by clear and convincing evidence? And that's, I'm just kind of narrowing the scope.
Point out that,
Can I finish, Your Honor?
No, you're going to get the last word, and I'm just asking questions because maybe we don't see it the same way as far as what the purpose of closing argument should be in a punitive damage case.
Your Honor, I just want to point out something is that when I brought up Ms. King, it was in reference to all the victims that in this community, nearly 100 who've been had some sort of injury by real water of this. And I believe that's the context. I didn't go into her injuries specific. I did talk about her MG, said she had MG, but I didn't go into her pain and suffering, all her losses. Right? It's not like I spent, it was a 1 second on it. And I think the same thing with Mr. Parker, but I'll let him address this. When he brought up Andrew Bordenave, it was the same thing. It was in the context of all the people that have been affected by this bad conduct of real water, which we're entitled to do under Nevada law.
That goes to reprehensibility, Your Honor. That goes specifically to reprehensibility. And, Your Honor, I think I'm entitled to the last word because...
No, but we're going to hear from Mr. Johnson. I mean, we're going to hear from him after you're done, and then you get the last word after that.
Go ahead.
May I proceed, Your Honor?
Yes, you may, sir.
Thank you, sir. Yeah, they did, indicated Ms. King was suffering for 7 years, made it about her again, the most sympathetic of the plaintiffs based upon the compensatory award. Arrived at, same thing with Mr. Parker. You know, that's what it is. Now, what they really, at the bench conference, and that will be in the record, they believe that there is a law that states the jury can't know that the plaintiffs are receiving the punitive damages award. However, they are determined. It's determined to deter and punish. Plaintiffs are getting the money. There's no case law that says you can't say where the money goes. I simply said it's about the money and what the plaintiffs are claiming in terms of punitive damages based in the context of your instruction. Never said to go beyond the instruction. I'm the one who's been quoting the instruction. This is just another attempt to try to turn the jury against my client by coming up with these little curative statements disguised as some sort of admonishment that I did anything wrong in this particular case. This has been going on and on. It didn't work during the case in chief, obviously, and it's not going to work now. What we want is to be able to make our closing that was supposed to be an hour. They've been up to 2 hours. And that's why we need to move on. There does not need to be yet another curative instruction. If by compromise the court wants to read the punitive damage statute again, the instruction, that's fine. But this is all gamesmanship. Thank you.
This is not gamesmanship. This is trying to make sure the council stays within the ethical rules in this jurisdiction as well as the law. The jury instruction says nothing about where the money will go. It is inappropriate, and as Mr. Kemp said, told the court, you should remember that Mr. Roberts tried the same thing in the HMO case, and we shut him down in that. And this curative instruction has to be given. As I said, I think it should be much stronger than this, and Mr. Johnson has to be instructed by the court not to engage in any further conduct like this in his closing. Go ahead.
Judge, I've got the final word.
Yes.
First of all, I don't know why Mr. Johnson's happy losing a verdict that all ends going to be $140 million. I did the math. So if he's happy having $140 million compensatory, good for him.
Great job.
So great job. So, but he keeps saying plaintiffs are getting the money. First of all, that's not even factually right. Because he knows his insurance company's taking a position that they don't cover for punitives. They're not going to really pay this. Real Water's in bankruptcy. We're limited to the insurance proceeds. So realistically, the plaintiffs, whatever the punitive award is, there's no factual basis for his assertion they're getting the money. That insurance company has refused to even pay the compensatory damages.
Well, I guess
That's why
they're
they
party
have-
now, Your Honor. We're going to let that cat out of the bag?
We're just arguing right now.
So the insurance companies refuse to pay the compensatory. That's why we made 11 offers of judgment, some as low as, well, very low, and his insurance company, presumably on his advice, refused to pay 10 of them, Your Honor. That's why he's stuck for the $140 million. But getting back, and
Your Honor,
congratulations,
I have to object
congratulations.
because this is basically a press release. Right.
Well, you
Let's
started
let's
this,
get to
you
the
started
point.
this by saying what a great job you did losing $140 million of compensatory.
Let's get to the point.
Okay,
You have-
the point, Your Honor, is at the bench, he admitted, and I give him credit for being candid at the bench, he admitted that he was trying to argue to the jury that they should give less because the plaintiffs are giving money.
Absolutely.
That's, you admitted that, the record is there. You were nodding your head.
The pitch is so high, a dog's barking in Nye County, Your Honor.
Whatever that means. But in any event, Your Honor, he violated Leochi. He clearly tried to insinuate, imply, whatever word you want to use to the jury, that they should give less because the plaintiffs are getting money. And that's just not appropriate. That's not the purpose of punitive damages, and that's why this This is relatively minor corrective, I think.
Your Honor, I've been quiet for the most part. Jury instruction number 1 goes completely against what he said, and it goes back to what you said. This is an attempt at jury nullification. It says specifically in jury instruction number 1, not to compensate the plaintiff. Any suggestion to the contrary is an attempt at jury nullification. And that's it. I mean, this is not a very complicated issue, as much as Mr. Johnson would like to make it, but it's not. And I think you should just rule with the pattern jury instruction on the issue, Your Honor. I think that's consistent. No, I know, but the decision turns on this jury instruction. And that's what I think.
It does, Mr. Parker.
Thank you.
Mr. Johnson, anything else you want to add to that, sir? I just want to make sure there's nothing I'm missing. Because at the end of the day, when I look at this, and the jury instruction is pretty clear, and you made a statement, and implicit in the statement is, well, I don't know if there's any law where I can't argue that the punitive damages are going to be received by the plaintiff or going to the plaintiff. But that's contrary to the jury instruction. And just as important too, that's one of the issues that were raised in the Leoshi versus Cohen case. And what our Nevada Supreme Court said was, and they concluded that the arguments amounted to impermissible jury nullification. Because at the end of the day, can we make arguments that are contrary to the jury instructions? No, we can't. That's ultimately what it comes down to. And I just want to say that. Now I'm looking at the instruction.
Your Honor,
Yes.
you're going to make your ruling, and I respect whatever it is. Leochi doesn't even address punitive damages, to my knowledge, but...
No. It's not. You understand this, and I agree with you in that regard. It's not a punitive damage case. It's not at all. But ultimately, what it deals with, and you can tell me if you agree or disagree with that, can you make arguments in front of a jury that are contrary to the law?
Well, of course you can't, Your Honor, nor did I make
Okay.
arguments that are contrary to the law. What I disagree is, the jury instruction says you have to base punitive damages on not based upon the plaintiff's cases. It's to punish and deter. Didn't say, but they get the money, Your Honor.
What money are we getting?
The punitive damages.
What money? We get a judgment that we have to sue the insurance company.
Whatever the problem is on how they're going to get the money is relevant.
But none of that's really relevant in this respect, because at the end of the day, what does the law say? And I'm looking at the Nevada jury instruction number 1. It says, the amount of punitive damage award is not to compensate the plaintiffs for harm suffered, but what is reasonably necessary to punish and deter the defendants and others from engaging in conduct such as that warranting punitive damages in this case.
Yeah,
And
that's
the jury,
exactly what it says, Your Honor.
yeah, and the jury has made a determination in this case, based upon clear and convincing evidence, that there was a conscious disregard, right? And that's one of the, that's what they've done.
Right.
So consequently, it seems to me that when you make an argument discussing putting up the dollar bill signs and the monies are going to go to the plaintiff, how is that relevant or even a consideration that should be made by the jury in their deliberations in this case?
Not.
I've made my point numerous times, disagree with it. I respect that. The instruction is unnecessary.
No, it is very necessary, Your Honor.
I didn't apply it that the amount should be reduced by inappropriate reasons.
Yes, you
Never. I keep hearing something.
I'm looking at it.
It's your conscience speaking to you.
No offense, but my conscience is not going to come from Robert. It's just not what was stated. Did I ever say anything, you need to reduce the award?
Judge, you put
Any
the-
type of, there it is again.
I'm listening to you, Mr. Johnson.
Thank
I'm
you,
listening
Your
to
Honor.
it.
I
I'm listening
appreciate
to it.
that. And inappropriate reasons? No.
Judge, he stood there, he put the dollar sign up, he said, this is about the money 3 times, and then he looked over at the plaintiffs.
Not plaintiff's counsel, the plaintiffs.
Okay, so what else was he doing? And he was pretty candid about this at the stand.
Oh my God.
I can see he's backtracking now. But
Yes.
this is an appropriate instruction, Your Honor, what happened. And as I said, for inappropriate reasons, I don't think we can spell out exactly what he did to the jury. That would be reinforcing his inappropriate argument for them.
It's not only appropriate, it's necessary, Your Honor.
We just put blinders on it, Your Honor. Maybe that's the curative.
Well, I'll stipulate that, Your Honor.
You'll stipulate to what
I'll
bond?
stipulate to his agreement to put blinders on. I'll
Oh, okay.
stipulate.
And muzzle though, too.
Mr. Kim, since you propose this, what about the quote, for inappropriate reason, end quote?
Judge, you have to say something, and I don't want to say what he did, because if we say that he argued to you that the money should go to plaintiffs give less, we're just reinforcing his improper argument. So that's why I think it's better to say just inappropriate reasons, kind of a neutral phrase.
Your Honor, if I may.
Absolutely, I'm reading it, I don't rush to judgment, I try to sit back and reflect, sir.
I don't mind inapplicable if that lessens it for me.
What do you want to say, Will?
Inapplicable rather than inappropriate.
And applicable. Your Honor, if you're going to give this, it should end at imply the amount to deter the defendants and others should be reduced, period.
No,
You're,
not enough.
Well, Judge, he's allowed to argue that the amount should be reduced.
Yeah, I know, I get that, I do. I get that.
I think inapplicable is pretty neutral.
well, I don't agree with it, Your Honor, but it's certainly better than inappropriate.
Well, that's why, Mr. Johnson, before I get it, I read it, and I just didn't get it. And there's other ways I could go as far as that's concerned, but I wanted it to be as neutral as possible. I don't mind telling you that.
Well, I appreciate that, Your Honor. Let's see here, and others should be, amount to deter defendants and others should be reduced. I don't even understand the others, it's about the money, and implies the amount to deter the defendant and others, I'm sorry, should, Your Honor, subject to my objection, it's fine to just get this thing on, whatever the inapplicable reasons were.
All right.
I mean, we're gonna be back here Monday, we're gonna get moving, right?
Oh, we will. I know Mr. Parker was saying irrelevant reasons.
Yeah, you heard that?
Oh, there's nothing wrong with my hearing.
No, I thought I was whispering.
No.
Now you tell us, your mom.
I hear everything.
Oh, that was good.
My memory's pretty sharp,
Oh, very sharp.
you know.
But I will tell you, my wife has told me I'm the worst whisperer.
Oh, is that right?
Yes. I truly thought I was whispering.
From a legal perspective, is Mr. Parker wrong?
What's that? I'm
Is
sorry.
Mr. Parker wrong? Should it be irrelevant?
I think it should be irrelevant, John. That's what I was telling Mr. Kemp and Mr. Agler.
Yeah, I don't care.
I thought we had a deal, Your Honor. We're gonna go
Well,
back.
if you want to go back, you deal.
They want the deal, Your Honor, then?
Okay, that's fine.
That's inapplicable, Your Honor.
Yeah, that's fine. I was thinking irrelevance more of a legal, you know.
Me too, Your
I
Honor.
appreciate it, Your Honor.
All right, that's what we'll do. We'll go with the inapplicable. And the reason why I didn't want to give inappropriate, I didn't want to imply that you did something wrong.
As long as that, I didn't do anything wrong, Your Honor. I appreciate it.
Well, I don't make that ultimate determination, but, you know, I'm trying to give you the benefits.
Thank you, sir.
All right. Do we have the jury?
Yes, Your Honor.
We're ready.
Just for the record, Your Honor, I've never claimed to ghostwrite the Gettysburg Address. No lawyer order is all would
Right.
restrict himself to 100.
It's not that he's not that old, he just never claimed that.
That was kind of funny.
We can, I don't know what it matters as long as I sign it, but you decide what you want to do, it doesn't matter. Yeah, I know, but that maybe it would change, that it shows that I put in applicable versus inappropriate. Yeah, you can do that. We'll do that.
I was just gonna put like a curative instruction heading and
You can do that, that'll be
I'm just
fine.
gonna type it.
It'll be part of the record, doesn't it?
All rise, the jury.
All right, do the parties stipulate to the presence of the jury?
Yes, Your Honor.
Yes, sir.
Ladies and gentlemen, before we get started, I just want to read to you an instruction for the record. Quote, "A punitive damage award is not to compensate the plaintiffs. Mr. Johnson has argued that this is about the money and implied that the amount to deter the defendants and others should be reduced for inapplicable reasons. Your sole focus should be on determining an amount reasonably necessary to punish and to deter the defendants and others." Period, close quote. All right, Mr. Johnson, you got the floor, sir.
Thank you, sir. Destroy the only place that was said in the closing waiver to is that real water, part of the evil corporate empire, is trying to destroy the only place of hope. Real water. That's the argument. That's what they want to deter and punish real water for, based upon passion and prejudice, which is not supposed to be the focus here. To punish and deter. But we hear about evil corporations. At the same time, we're supposed to be fair, according to the jury instructions, and unprejudiced treatment to corporations. That's the law. Be fair, don't be prejudiced, but they're evil now. That's not right. That's inconsistent with rules that have been given to you. Proud moments in our history, American history, talk about the bottled water industry. You didn't hear any testimony about there being some sort of industry-wide problem with the bottled water industry, bottled water everywhere in this trial. Talking about profits over safety. Hear anything about that, did you? No evidence. And then the constant, albeit unintentional, business of insulting your intelligence. You have been here for a month, can you believe it? Okay, hardcore. And then after all your hard work, almost an $80 million award in this case that y'all worked on, that's a slap on the wrist. That's what they said.
Your Honor,
That's
we
slap-
may approach, Your Honor.
Of course you're gonna broach.
Judge, you can't equate compensatory, now he's implying that compensatory serves the purpose of punitive.
I said nothing about, I said to the jury, if they don't award enough, a minimal amount of the punitives, it's a slap on the wrist. He is completely distorting and lying to this jury, like he's done throughout this case, lying to this jury about what I said, okay, and what happened here. This is, I mean, as I told you, unless there was, this is why I wanted something stronger, because this is going to continue. This continual Leochi violations and bad conduct, unethical, is going to continue unless the court shuts it down.
I guess he forgot what he said, Your Honor.
I didn't forget. I know exactly what I said.
That's a slap on the wrist.
But
It doesn't
see,
want to
here-
accomplish
here-
anything.
Not for compensatory
Unless-
damages.
Yes, you
No,
did.
No, I
But
didn't.
here's
You don't
the
listen.
point.
You
Here's the
don't
point.
listen is your problem.
I mean, part of the argument you were making was essentially this: there's no evidence from Coca-Cola and those types of things, and that's not really germane to the punitive damage issue because Coca-Cola or the rest of the industry is not really on trial here. Real Water's on trial. The jury's made a determination based upon clear and convincing evidence there should be an award of punitive damages. So my point is this: whether there's been any violations or anything like that by Coca-Cola really doesn't matter, or Sprite and or Pepsi Cola and all those things, because at the end of the day, that's where the deterrence is. The punishment is Real Water. They will be punished, but there's the deterrence component, and you don't have to bring up evidence that, for example, what other bottlers are doing. The point is, other bottlers won't go astray based upon the fact that they know there's a possibility of
I
punitive
want you to
damages.
hear, because this is word for word what I said. It's on my computer, okay? So what do you think will happen if you give them a pass, if you let them off with a bargain basement verdict with your punitive damages award, a slap on the wrist? I clearly was talking about the punitive damage, not compensatory damages. Again, he lied.
Yeah,
No.
the problem is what I came up with first from. He is equating the compensatory award as somehow adequate for the punitives in this case. He's asking the jury to say, okay, you already gave enough, so you shouldn't give more because compensatory is really the punitives. That's not a problem.
Your Honor, the record will speak for itself on what Mr. Baker stated.
The record is
I
right
don't
here.
know,
I
the
said
record
word
isn't-
for word.
The record isn't on your script.
Oh,
Point
it
Your
is.
Honor, is that was what Mr. Baker said. That's a slap on the wrist. So again, here we
Not
are
for
under,
compensatory.
and also,
I didn't say for compensatory, Judge, and that's what he told his jury.
and also what's been stated is, are you stating now, Your Honor, we can't bring up the fact that
What? No, go ahead.
they're
I'm
the
listening.
ones who brought up Coke and Pepsi and how much money they make to arrive at their punitive damage award.
That's not what I said. I didn't
Okay.
say you. But what you said was, you were saying, look, there's no evidence that Coke, Pepsi, or
Right.
them have displayed conscious disregard or anything like that. That's not. Of course, any sort of evidence like that would not be admitted in this case. The point is to deter future bottled water manufacturers from similar conduct.
It's not whether they're engaging in conduct now.
Right.
Yeah, yes, it is. They're making a broad-based argument that the industry has to be deterred from doing this very thing.
No,
There's
that's not
evidence-
the argument. No, you don't understand the argument, I don't think. What they're saying is, look, if you punish Real Water based upon their reprehensible conduct, that will have a deterrence factor on the rest of the industry.
They don't need to be deterred from any of this conduct because they don't do it.
How do you know?
But see, if that's the case, then there would never be punitive damages. because that's the deterrence component, right? Just because the rest of the bottle manufacturers are doing fine now because they're doing what's appropriate, if they realize that, you know what, maybe we can get away with this and we can start cutting corners. And that happens with businesses.
Judge, can I suggest we just read the curative one more time and move on?
I would request, Judge, that you instruct the jury to disregard his argument from when he started after the break until when you had this bench conference, because everything he said was a violation.
You know what, if they want to address it, they've got the rebuttal, Your Honor.
I understand.
This isn't about rebuttal. This is about misconduct.
I mean, I don't like dealing with this. I'll be candid with you, but if you read Leoshi, I have to deal with this as the trial judge.
You do.
I understand. I don't
Yeah,
know
I know.
anything.
Yeah.
Compensatory on fine.
What?
That's lower punitive damages than compensatory. That's wrong.
Yeah, it's absolutely wrong. And talking about there's no evidence that these other companies are violating or having problems or violating. That's irrelevant, Your Honor. It has nothing to do with this. It's the conduct of the real one.
Judge, I think the instructions, same kind of conduct, same instruction.
All right.
Can
you bring us home, sir? I'm just. I mean,
Trying to
I
bring
don't.
us home, Your Honor.
I understand, I'm going to follow Mr. Kemp's lead. I'm not going to go heavy-handed like you, Mr. Eglin, want me to.
At some point, I think you're going to have to.
All right, ladies and gentlemen, I just want to remind you that punitive damage award is not to compensate the plaintiffs. And for that reason, you have to understand that the amount is to deter defendants and others and should not be reduced for inapplicable reasons. Your sole focus should be on determining an amount of reasonably necessary to punish and deter the defendants and others, period. And consequently, as a result, the objection shall be sustained.
Thank you, Your Honor.
All right.
So let's talk about real water and the deterrence to other companies. Pull up the John Harlow slide, please. This is what we need to deter, punish. We need to make sure that we don't hire an individual who created alkaline water with titanium tubes. We need to prevent that from happening. Go ahead. Next one. Brent Jones. This is apparently the Sam Walton of real water. We need to deter people from being aware of customers. We need to deter that. Let's go to Blaine Jones. Unless the various executives, they need to be warned to deter, to go fund the guy. We prevent that from happening. Mr. Rich, in opening, said that they're going to ask for $5 billion in opening. Let me take Mr. Rich's appropriate names, that's just 2 days ago, down to $2 billion. And then today, it's up to $3 billion. What is appropriate? I trust that you guys will find out what's appropriate financially that you want to punish. Ladies and gentlemen, $80 million is a deterrent to anybody.
Your Honor, Judge, should we approach?
Judge, how could he have done that again? After that bench conference, how could he have done that again?
Your Honor, there needs to be a sanction at this point, and he needs to be admonished in front of the jury.
$80 million is a deterrent to anybody.
Is-
$3 billion.
It's supposed to be the same amount that
So
you told
what?
the jury was given to them.
Jesus.
Why wouldn't it be?
Have you ever argued a punitive case before? It doesn't seem like
It's funny is, we're about to find out. They threw up a $3 billion number.
that was so incredibly inappropriate. The Ochi violation, he clearly just violated the jury
What's the
instruction.
violation, John? I
It's,
can establish.
it's not to compensate. It's compensation is compensations for the harms and losses. It's not the deterrence.
Don't you think maybe it's the way you said it, right? You said, quote, $80 million is enough to deter anyone.
Right? What's wrong with that, John? That's not a deterrence.
But isn't that what the awards are in this case? $80 million?
Compensation.
Yes.
Yeah.
You're
more
going
than
to
that.
double.
Yeah, it's
You're
more
going
than
to
that.
double the $80 million award. That's not punitive damages. That's not going to deter. This is just
He
more
cannot
jumping up the
say,
flames.
he cannot say it's a Ryochi violation to say that the compensatory damages are deterrents because they're not.
I didn't say that.
Yes, you did.
Okay.
It's
I
enough.
said
It's enough deterrents.
No, I didn't.
Yes,
Maybe
you
you
did.
just-
That's exactly what you
Maybe
said.
you just misunderstood it. And if that's what you thought, then that is it. I'm talking about an additional $80 million.
But you didn't say that.
Well, I did say that because I'm talking about it in the context of deterrence and punitive damages. Are you saying it doesn't have context?
You didn't say that. Come on, man. Just gotta be honest. Be intellectually honest with yourself at least. Come on. You didn't say that.
We're talking about the amount of money to deter them. $80 million is more than enough. That's what I said.
If he'd said 100 million or 150 or 50,
But that's
we
not,
wouldn't have
he
objected.
said
but-
the
but he-
compensatory
number that
damage.
was-
He said the compensatory damages are 80 million. That is enough to deter anybody. He's suggesting they don't
But
give
see, that's-
zero.
That's not what I'm suggesting.
Oh my God, come on.
What, do I have to make it more clear?
This is almost comical.
It is comical. For you two guys to keep running up here. I was talking about in the context of deterrence, Your Honor.
You didn't say that,
He
though.
didn't say that.
Judge, if we could just have the instruction read one more time.
No, we don't.
No, Judge, I told you that when
Oh,
we
he's
were back.
telling you now.
I told you when we came back, you're going to go with Mr. Kemp at this time. And I said, it's going to have to be something more later. And here we are right back up here again because he refuses to follow the
That is-
rules with regard to punitive damages and what he can say and what he can't say. And he clearly, I know you heard it, Your Honor, he clearly said, you've awarded $80 million in compensatory damages. That's enough deterrence for anybody.
That is
That's his point. Yeah, it
Talk
is.
about what is the amount to deter? I said $80 million is
Judge, I want
enough
to
to
get down.
deter.
That's right.
I'd be more than
It's not
happy
what he
to
said,
read it
Judge,
one
and you
more
know it.
time.
It's not what you. It's not what he said. I think you need to add something to it, Judge. I think he needs to be admonished that his arguments are inappropriate.
Can we?
I think not applicable needs to be changed to not appropriate, Your Honor. Back to appropriate at this stage. It's not appropriate.
There's no reason to read it
There is, Your Honor.
because of a misinterpretation of it.
No,
If I can get
no,
up there
it's not a
and make it more
misinterpretation.
clear, I'm certainly
Not
willing
a
to do so.
Oh, you at this point? No, it's not a misinterpretation. It needs to be inappropriate, Your Honor.
I really find
I
it.
think inapplicable is fine.
What?
Your Honor.
Inapplicable is fine with me.
Okay, I've got a client in this case, not
I
just Mr.
understand.
My
I
client
do.
is the biggest hurt. It's got to be inappropriate at this point. This has got to escalate. It's not going to stop until you stop him. I've got a client in this case where whatever the
I'm fine
punitive
with escalation.
damages
It's
are
okay.
more than, so it's got to be inappropriate, Your Honor.
It isn't.
It is inappropriate. It's beyond inappropriate. It's unethical.
You know, we're not going to have dinner now.
Okay. It breaks my heart, Brett.
Mr. Johnson,
Yes.
do you think, can we be done by about 3:15?
Yes, sir.
Okay.
Inappropriate, Your Honor?
Oh, that's what I'm putting in.
Okay.
Okay, ladies and gentlemen, I just have one more curative, and for the record, a punitive damage award is not to compensate the plaintiffs. Mr. Johnson has implied the amount to deter the defendants and others should be reduced for inappropriate reasons. Your sole focus should be on determining an amount reasonably necessary to punish and deter the defendants and others. Period. Close quote.
Thank you, Your Honor.
Thank
You'll
you.
have to come up with a number you think is appropriate for punitive damages. What would that number be? The 5 billion, no basis, I'm asking for it more. 3 billion, no less, or yesterday said it was 2. But you have to make that determination based upon reason and intellect and ability to understand and what your feeling was in terms of why you thought punitive damages should be awarded. In this particular case, is that those punitive damages could be, you have an amount of money that would be beyond that and not linked to compensatory damages. $100 million? Is that what's going to punish and deter other folks? You'll have to make that determination. Quite frankly, based upon your verdicts and how long you've been considering things and making notes, etc., I trust that you'll come up with a fair number. But it has to be reasonable. It can't be based upon prejudice and passions, etc. I've actually only spoken, I think, 4 minutes, believe it or not. So I respect the court, respect the jury instructions will be followed, and above all, I respect you guys. Thank you.
It'll be in the record. Mr. Parker.
May I proceed, Your Honor?
Yes.
I almost forgot to even ask. I apologize, Your Honor. All right, someone is timing me, Ms. Garcia. I'm gonna be brief. I am going to be brief. The judge has admonished Mr. Johnson, I think 3 times for his inappropriate conduct.
Yes, Your Honor, I was not admonished.
I'll sustain.
Thank you.
I'm sorry, he instructed the jury. I'll go with that. But Shane, let me put something on the screen for me. Jury instruction number 30. This is the reason why we're here, why we're having a punitive damage phase. At the bottom of this instruction, it says, at this time, you are to decide only whether real water engaged in wrongful conduct, awarding an award of punitive damages, and if so, whether an award of punitive damages against real water is justified by the punishment and deterrent purposes of punitive damages under the circumstances of this case. If you decide an award of punitive damages is justified, you will later decide the amount of punitive damages to be awarded after you've heard additional evidence and instruction. You've heard the evidence, you've heard the instruction. Did you hear any evidence offered by Real Water? Did they bring a CPA in and say, you know something, Mr. Parker or jury, $2 million is not what's necessary for a positive effect? I'm sorry. 2 billion. I apologize. Thank you. Did they bring in one expert to say that that figure was wrong? Mr. Johnson has repeatedly said it's the evidence, not the argument. And you probably noticed by now that I try to let all the witnesses in the document speak for me. I show them to you, and I take my time doing so. But I don't ask you to take my opinion. The expert that we put before you has done the research. They've brought no one here to refute that. No one. And then he gets up and says, based upon whatever, you make a decision. I like Mr. Johnson. I got his cell number.
Must be.
He has mine. But this is not about Mr. Johnson, it's not about me, it's not about Mr. Kemp or Mr. Eglin. This is about the evidence in this case. And we want you to make a decision because you agreed to, at voir dire, you agreed when you took that oath that you would make a decision based on the evidence. Not whether or not you like Mr. Johnson more than me or me more than him. That has no place in your decision. No place whatsoever. Your decision has to be based on the evidence, and the only evidence you've heard came from Mr. Rich, Mr. Mark Rich. Next slide, Shane.
Which slide?
Number 22, one of my favorite slides. Jackie Robinson said, "A life is not important except in the impact it has on other lives." Mr. Eglin was correct. This verdict, if it's the appropriate verdict, will make an impact on the lives of others. No one will be exposed to hydrazine or feces or anything else that shouldn't be in bottled water, something that you can't live without. This person, Mr. Robinson, was a man of very little words. He let his personality, his strength play out on the field. So if you take nothing away from this, I want you to understand that whatever you do today will speak volumes. Volumes. This is the field. And what you do today will speak volumes. Next slide, Shane. Number 23. And this is all I ask of you. This is all we ask of you. Now, a lot of you may not know who this is. But this is one of the few, one of the first females of color who participated on behalf of NASA. She was a mathematician. And she said, "I just try to do my best every day, and I want to be remembered for trying." All we ask is you do your best today to come up with the appropriate amount so that this never happens again. That's all we ask, and we have trusted that's exactly what you'll do. Thank you so much.
Okay, thank you, Mr. Parker. And Mr. Marshall. And ladies and gentlemen, what will happen now is we're going to be in recess. The marshal is going to escort you back to the jury deliberation room. We have the appropriate instructions and another verdict form for you. All right, they're in your possession, sir.
Okay, all rise to the jury. Bring all your stuff, Chris.
Off the record. If you leave, I guess we have their phone numbers, right?
We have their numbers.
Yeah, Judge, I think we're gonna hang around.
All
We're
right.
on the record now.
And let's go ahead and set forth our appearances for the record.
We'll count for plans.
Good afternoon, Your Honor. Teddy Parker, plaintiff.
Good afternoon, Your Honor. Robert Eglin, plaintiffs.
Maggie Feathers for plaintiffs. Brianna Switzer for plaintiffs.
Brad Johnson, Eric Freeman, Michael Esposito, and Tyler Watson for the defendant's yard.
All right. The jury has a verdict, and we can go ahead and bring them in. You can pick up Monday. And you can have fun.
No, I think this jury doesn't do it.
So has it been 4 weeks?
Exactly.
Yep. On the money.
Fourth, end of court week.
Gonna take day
20
close to the wire.
Yeah.
You did finish on the date we told them.
I was getting ready to say that.
Yep.
Or a chair? Well, that's a chair. You use a chair. Well, no, which chair is it? Yeah, those are so much fun. You know? Is that a silent auction? Of course. For this one.
All rise for the jury. May be seated.
All right, do the parties stipulate to the presence of the jury?
Yes, sir.
Yes, sir.
All right, and Mr. Foreperson, Mr. Dixon, has the jury reached a verdict as far as the punitive damage phase is concerned?
Yes, we have, Your Honor.
All right, will you please hand the verdict to the court martial? Thank you, sir. And let the record reflect, I'm handing the punitive damage verdict to the court clerk to be read in the record.
District Court, Clark County, Nevada, case number A-21-831725-B, Department 16. In the case of Nicole Chang, an individual, Andrea Bourdonnais, an individual, Nigel Davis Richard, an individual, James Delmar, an individual, Vanya Diaz, an individual, Kathleen Gossius, an individual, Lisa King, an individual, Ginger Land Van Buren, an individual, Carrie Mono, an individual, Glenn Morris, an individual, Cheryl Nally, an individual, Abraham Olvera, an individual, Carolyn Strong, an individual, plaintiffs, versus AffinityLifestyles.com Incorporated, DBA Real Water Corporation, Real Water Incorporation, a corporation, defendants, punitive damages verdict. We, the jury, return the following verdict. Punitive damages are awarded against Real Water in the following amount. $3 billion, dated this 21st day of March 2025, signed jury foreperson. Ladies and gentlemen of the jury, is this your verdict as read?
Yes.
Thank you.
Okay, do any of the parties desire to have the jury polled?
No, Your Honor.
No, Your Honor.
All right. Okay, ladies and gentlemen of the jury, and just as important too, I think this is often overlooked, and I do this every time we dismiss a panel after reaching the verdict. I want to thank each and every one of you for your service, and I think it's important to point out we can't overlook those individuals that served as alternates in this case. I always bring that up, and I want to thank you because although you're an alternate, you didn't participate in the ultimate decision-making, nonetheless you served. And for example, we've lost 2 alternates in this case, I think, during the deliberations. And potentially it could have been a panel member. We lose, and consequently they move into that position. But as a whole, and that's why I bring that up, I want to thank you for coming down here and serving. Because it's my recollection, our journey together started approximately, 2.5, 3 months ago. When I first went down to jury services, and I think at the time there were probably about 300 or 400 of you, and I had a chance to introduce myself, and this was prior to filling out the jury questionnaire, and we swore you in. and it's my recollection, we had a discussion about quite a few things, and one of the most important aspects of our visit, I wanted to make sure you understood why you were there, right? And we talked about that. And it's my recollection, at the same time, I also talked about the preamble to the Constitution of the United States of America. We talked about the Bill of Rights, and we talked about a lot of things. And I remember telling you that it's my opinion that if you take a look at our United States Constitution, the mission statement for this great nation is the preamble. And remember also at that time we talked about, and I pointed out to you, what was the concern the founders of this great nation had when this nation was founded. And it was to establish justice. It's right there. And along with that discussion, we talked about our justice system and how it's different than any other system in this country, in the world. And what I mean by that is this: ultimately, at the end of the day, under our system of justice, we don't have special tribunals or judges coming in and deciding the ultimate outcome. The ultimate outcome, as far as our jury trials are concerned, they're decided by you, the people. You understand that? Together, you know, as a great nation. But I realize it's been a long time. I just want to thank, not just on behalf of myself, but on behalf of the citizens of Clark County, the citizens of this great state, the parties involved in this case. They've taken a long time to get to this point. And just for our system and our democracy, because it would not work without you. And I want to thank each and every one of you for your service. And so at this time, I'm going to discharge you and understand as far as being discharged. And there was an issue, you wanted to keep your notebooks, right? Isn't that, does anybody have a problem with that?
Absolutely not, Your Honor.
Okay. I wanted to make sure I answered that question. So you know the answer, right? You can keep them, which is important. But I just want to thank you for coming down here, because I know you took time out of your busy lives and you sacrificed. And we can't overlook that. And so anyway, I'm going to discharge you. The lawyers might have questions for you, and understand this, they'll never try to challenge your verdict at all. They accept it. Just as important too, if they have questions, it's more like from a clinical perspective. And they might have questions for you regarding their arguments or regarding the evidence or how you felt about this or that. But it's never to challenge your conclusion. You understand that? So anyway, thank you for coming down. Thank you for your service. And believe it or not, we had a case just recently where we had one of our prior jurors in one of my cases back again, you know. And so maybe somewhere in the future we might see you again in Department 610. Right. You never know. I was surprised at that. And it was within 4 years. They're back again, you know. But anyway, thank you for your service, and you're dismissed.
All right, to the jury.
Oh, Lord.
Thank you.
Yeah, we can go off the road.
No, wait. Yeah. We need to all unuse unoffered depositions.
Okay. All right, wait. We have one housekeeping matter before you leave.
Stop it.
We have one housekeeping matter, and the clerk needs something regarding returning depositions and
Yeah, I
all.
just have to say this on the record that all unoffered, unused depositions are going to be returned back to council.
Thank you.
Thank you.
All right.
Thank you, Your Honor.
Oh, you're welcome.
Thank you very much, sir.
You're welcome.
Thank
You're
you,
welcome.
Your Honor.
Thank you, Your Honor.
Oh, you're welcome.
Thank you, guys.
Do you want to scrub? We'll take ours now.
Okay, yeah.
What about the jury questionnaires? Did they say they would shred them?
Oh, shoot, I forgot to do
Judge,
that.
could you ask them that real quick? We can shred the jury
We
questionnaires.
can shred the jury questionnaires, can't we? Yeah.
Thank you so much.
Oh, you're welcome. It's been a while since I've seen you in here.
Counsel, can we shred the jury questionnaires that the department?
Case,
Oh, yeah.
in the Route 91 case, I was in COVID. I hadn't tried a case in 5 years. So I was like.